Court officer. Court officer. Court officer.
ಹೇಳಿ ಸರ್.
ಇಲ್ಲ ವಾಯ್ಸ್ ಬರ್ತಾ ಇರಲ್ಲ, ಅದಕ್ಕೆ ಫೋನ್ ಮಾಡಿದೆ. ಕೋರ್ಟ್ ಆಫೀಸರ್.
ಹೇಳಿ ಸರ್.
ಓಕೆ, ಥ್ಯಾಂಕ್ ಯು.
Yes. Here number 4. Hi. Already. Friday. Already. Market presence. 1 minute. Item number 9. Learned Advocate General submits that in compliance of the which order in compliance of the earlier order, he will produce what documents in the report.
What report in a sealed cover?
What report? Report in a sealed cover. Sealed cover on the next date of hearing. Learned counsel for the petitioner submits that the petition to be heard on Friday. What?
Third.
3rd of February. Just on 3rd of February 23.
Serial number 17, madam. List number 2. Kindly be taken next week, madam. 8.
17. 17.
List number 2.
And counsel for the 14% praise for adjournment. List for the next.
7th
Next
or
week.
8th. 8.
Next week. Next week it will come up. Yes. But tomorrow. Thursday. Okay. So what is the urgency? Thursday. Why? You are going for a movie, morning show, 11 o'clock. Huh? Why? Where is the other side? Did you tell him that I am going to seek an adjournment at 10:30? Supposing if the case is called and when he comes, what do we tell him? That the other counsel was in a hurry, he had to go for a movie. That's why we have adjourned the case, right? Out of turn. What inform? You wait. Can't you wait? Please wait. Let him come. What non-filing of objections to pleading? Huh? You don't have objection? Or on IA 1 of 21, learned counsel for the applicant submits that he has no objection to the application, namely IA 1 of 21 being allowed in view of opposite submission and for the reasons assigned in the application form are duly supported by an affidavit, same is allowed. Let cost title be amended within a week. Finishing 6 and 7. 2 weeks failing which appeals shall stand dismissed for 6 and 7. Take appropriate steps for review for notice shall stand dismissed for 7 and 40. Settled.
Report is not here.
What is not there?
Not here.
Clear. Oh, I thought not there.
Bank
Not clear.
details.
Separate written agreement is.
Mr. Raj.
It has been settled, madam. Huh? Where is the mediation? Where is this thing? Do you have the copy of terms? Settlement. Oh,
ಎನ್ಕ್ಲೋಸ್ ಮಾಡಿದೀನಿ ಅಂತ ಹೇಳ್ತಾರೆ ಅದು ಎನ್ಕ್ಲೋಸ್ ಮಾಡಿ ರಿಪೋರ್ಟ್ ಬಂದಿಲ್ಲ ಅಂತ ಹೇಳಿ
Then there is a separate agreement, right?
separate agreement.
ನಾಟ್ ಸೆಂಟ್ ಐ ವೆರಿಫೈಡ್ ಇನ್ ಫ್ರಮ್ ದಿ
Password, you get it?
ಫ್ರಮ್ ದಿ ರಿಜಿಸ್ಟ್ರಿ ಐ
Password, madam. We have not got the agreement, separate agreement. We will get it from mediation center and pass an on.
ವೆರಿಫೈಡ್ ಮಾರ್ನಿಂಗ್ ಶೇರ್ ಫ್ರಮ್ ದೇರ್ ಇಸ್
Mediation center was
Yes.
in the. Time is granted to comply with office of the. Seventh February 23. Just on 7th February. For orders on admission.
I appeal for the appellant, my lords. Pray for a week's time, your lordships.
Weeks peremptory.
Obliged.
For the reasons assigned in the memo, or the service of notice on respondent is insufficient. And who is accepted, admitted for hearing, record.
Javid, yes. Government Advocate, C.N. Krishna Gowda.
What is it? Huh? Oh, fortunate, Mr. Yes, that minor boy, right, son? This petition has been filed seeking a writ of habeas corpus for production of so and so. Namely, the son of the petitioner, learned High Court Government Peter, has filed a status report in which in paragraph 14, it is stated that the in which it is stated that that a criminal case for offences under section that a case that on the basis of complaint made by the petitioner dated 14/5/2022, crime number 57/2022 has been registered against respondent number 3. During the course of the investigation, it has been found that that respondent number 3 has murdered the son of the petitioner. Full stop. In view of aforesaid averment made in the status report, nothing survives for adjudication.
Corpus is found.
No, you say that during the course of investigation, the respondent number 3 was subjected to polygraph test, and it has been found that he has allegedly murdered respondent number, the son of the petitioner. Full stop. In view of aforesaid, nothing survived for adjudication in the petition. The same is disposed of with the liberty to the petitioner to take recourse to such remedy with regard to his grievance as may be available to him.
Number 10. Can we deal it?
Appear per applicant in this case, my lord. Praise time, my lord.
What praise time?
Senior hospitalized ಆಗಿದ್ದಾರೆ, my lord. 1 week time, my lord.
And so, what's your name? Ask her name. Then it counts to praise for adjournment on the ground that counsel is unwell. List after one.
Much trouble.
Huh? What is pleading? They are all feeling inspired by you to do the evening course, right? Huh? Ramesh, what happened? You filed the objections? Mister? When? Yes. But you don't want to file. You will, what pleading application we shall allow? All right, pleading IA 1 of 23. Learned counsel for the petitioner. But don't, I mean, before another application comes, we want to decide the case. Several more students will come. No, not stop. That's why before they come, we want to decide this. Out of IA 1 of 23 reasons assigned duly supported, IA is allowed. Let amended cost title be filed. When? When the amended petition be filed. Undertakes to file amended petition by tomorrow. List in the, when do you want? Day after. Day after is what? First. What to do? We are ready to hear you. You permit This treatment, you say you have no objection. We have to allow. But who is it? At whose instance it is being adjourned? Your instance, right? Ah. Okay. But because you are saying that I don't have any objection. If you would have opposed, we would have asked him to file a separate writ petition. Ah, so both, we will see what happens to the boat or day after tomorrow. Huh? Yes. What you don't want to file return, or what to do? You don't want to contest it. What will you know if some 5 names are given? What is the use? You don't want to file objection. You don't want to do anything. Then why do you want application for amendment? Fine. So then Mr. Ramesh will take care. Don't worry. You sail with him. Either he will swim or sink. You also, depending on his effort, you will also sink. What can be done? We don't know. You don't say every time we are not supposed to invite you to do something. You don't do it. Fine. You are saying that whatever happens. Fine. We don't know. It's for you to decide. It's for you to decide. We don't know. Yeah.
Hearing on IAS number 12. Ellen Ramayagoda.
Paper publication. Yes. What paper publication? IA has been filed for service of notice on which respondent?
3A.
3A and 3C. Their appearance before this court. Let this court be let notice be published for appearance of aforesaid respondents before this court on which date? 1st March 23 in Delhi. Bangalore and Kolar edition. Accordingly, IA 1 of 23 is
13. Sri Rohan Kotari. Government advocate.
Leak. What report? So you have to tell us. Ah. Almost 6 months long this thing. No, so you see, you had told us on the last date of hearing that you will apprise us with regard to further course of action to be taken for removal of encroachment. There is not a word except this. You are doing to protect them, right? Once they are protected, all this notification. Why this 30 days? Who will object? They know the benefits, right? They know once it is declared to be a slum, notified slum under the Act, they will be entitled to benefit and would be entitled to resettlement as a matter of right. Is it not? So what I mean, why should you, who will object? Obviously, it's for their benefit, right? You are. No, sir, is it not, I mean, is it not this all exercise in para 7 is intended to help the encroachers, right? Is it not so? Not remove means this notification section 11 you have taken us to June 2023. What happens thereafter? Not a word about Mr. No. So then, so then, so that means you have ensured that you will after 6 months you will give another report. That will take another 6 months. End of 23. Nothing happens. We quite appreciate your predicament, but you have to be like, this is pending since 2014, right? Nothing has happened. And then the fresh one, this thing 3-1 notification and all.
Go through at work. Usually because.
So why do you need the 15 days time, February? Why can't you issue it tomorrow? What's the you had also told us, right, that houses were constructed and that there was some scheme and all. So you mentioned, right, that
Not this. Not this. And don't want anything related with all of this. So like other slum not restricted.
no, we want to understand, like, I mean, what is this 6 months long drawn exercise eventually resulting into notification in favor of slum dwellers, conferring them the right to settlement, right? This is all, I mean, it's about. So who is going to object, right? Slum dwellers, if you say that we will provide you an alternative, this thing, will they say, no, we will stay on the lake only? Of course, I mean, they are in the zone of this thing comfort. So comfort. Okay, Mr. But you tell us the solution, Mr. All this is, I think, this 2014, right? 8 years. So we thought that with your appearance, I think we should be able to, but no. This is, no, but this petition is pending. Several orders have been passed. You have already conducted a survey. Your survey report is there on the record. All this has been done. Tell them, right? Why this exercise of 6 months? To after you tell us where would we be on 20th June 23. The encroachment would stand and 2 pieces of paper you will add that this is notification 3-1 and 11. What happens? What is this thing change in the ground situation? Nothing except two pieces of paper you will add and file that we have done. Who is going to object? This all. No, but you have to take action, Mister. This not, I mean, like it's just like buying time sort of thing. 6 months. Also, what the act itself provides 30 days timelines. Huh? No, what about 3? So like it's almost 2 months in Mr. 3-1 draft notification, almost 2 months, 1.5 months. You say that we will issue 3-1. And then April and again 2 months. This. So no, these timelines have to be reviewed and realistic. There's nothing like it can't be like 6 months. And there is no this thing. You have not said what thereafter. You have to simultaneously think, no. So if this happens, and hopefully is not subject matter of another litigation in which an interim order is passed. So eventually you will have to take steps for identify the places where they can be rehabilitated. To identify where closest to then. So you have to start the process of identification also.
Artist Day commemoration. Artist Day commemoration is 11 o'clock. Siren is not.
Siren is not.
You cannot heard. Not siren. 2 minutes. 2 minutes.
2 minutes are we have to write.
Yes, silent.
Realization.
Nothing, they can reach out.
Yes.
Mr. When Friday is better, right? Not Monday. Something better to do. So third, what third? Can it be on 3rd February? Yeah, 3rd February. Right, Mr. Mohan. Some other IAS pending. Next date. 3rd February. Which one of them? All right, we'll see what is your IA. We will decide on Friday.
2 days back, the Contempt Court, where they study of the report is so well.
Alarming. You must, yes. So, Mr. You have to take care of so many things simultaneously. Encroachers, quality of water, flora and fauna, everything. How ecosystem, prevent encroachment, everything simultaneously.
Water Act, they take action, that's the section 33. 102, that's missing.
That's what he wants. That cyber. If we ask you to take one particular step and you take 6 months time, what happens to Mr. Mohan's worry? He's justified, right? Friday. Please. Yes. File it on Friday. Yes. All right. 3rd February. 3rd February. Yes. 3rd February. Both your IA and Mr. Mohan's IA. Yes, right. Learned amicus giving praise for short accommodation. List on 3rd of February 23.
Hello, you'll do the same thing to me.
Hearing. Admitted. For order. For admission. So we list it for admission. Let the appeal be listed for orders on admission. The record indicates that the appeal has not been admitted as yet. Comma, full stop. Yet let the same be listed for orders on admission. Yet taken up reason and don't allow admitted record.
16, government advocate with Anusha.
government advocate, additional government advocate submits that amended cost title has been filed today. Office objection is therefore ignored. Let the appeal be listed for orders on admission.
And connected matter also, my lord, amended cost title is already filed, my lord.
In order.
Please.
6.1.
In this case, I'm appearing for appellant, my lordship. So, my lordship, there is a 3,276 delay in filing the MFA, my lordship.
Read counsel for respondent praise for and is granted 2 weeks time.
No, I'm not seeking time.
Objections.
I'm not seeking time, my lordship. I have filed an application for continuation of delay. Delay is 3,276, my lordship.
What is the lesson? You should speak louder so that you can your opponent who is in the comforts of his office can hear. And we are not sitting here to explain it to him what order we have passed. You should speak into the mic so that he can hear.
That any delay, asked occasion I can time to file objections.
So we have
That's why-
granted you 2 weeks further time by way of indulgence, right? Yes.
Lordship.
This is 21 appeal. IA 1 of 22 shall be considered in the month of March 23.
The 19, Omkar KD, Rupesh Kumar.
What vacating stay? What vacating? You want to get married? What? No. So all right, pass over. Pass over. IA 1 of
Prakash Diyar.
orders are necessary to be passed as the appeal is within limitation. What is yes? Yes, sir. Not here. It has been settled, right? You are filing a memo. Memo. Live together.
Who is Sandeep Sakre? Where is your advocate? Where is your advocate?
Hey, you come here. Ask him to come here, this side.
ನಿಮ್ಮ ವಕೀಲರಲ್ಲಿದ್ದಾರೆ ಮತ್ತೆ ತಾರೀಕಿಗೆ ನೀವು ಎಲ್ಲಿಂದ ಬರೋದು? ಏನ್ ಇದಕ್ಕೆ ಸೈನ್ ಮಾಡಿದ್ದೀರಾ? ರಾಜಿ ಮಾಡ್ಕೊಂಡಿದ್ದೀರಿ? ಸೈಡಿ
Idea.
ಸೈಡಿ ಇಡಿ ಕೇಳ್ರಿ.
Appellant in person, so as respondent, so and so. Along with respondent present, this appeal has been filed against judgment and degree dated 23rd June 2022, passed by the family court, by which petition filed by the appellant, no petition filed by the husband seeking dissolution of marriage. Dissolution, appellant seeking dissolution of marriage has been dismissed. Paragraph. Parties who have appeared before us have invited the attention of the court to the memo of compromise. The terms of compromise read as under 1, 2, 3. This was. Oh, much already. A petition filed by the appellant has been partly allowed, you say, partly allowed. And the marriage between the parties has been dissolved by a decree of divorce on the ground of cruelty. On these cruelty.
Petition filed by the respondent.
Acha, petition filed by the respondent husband, right? Party allowed, marriage has been dissolved, right? The parties who are present before us have invited the attention of this court to memo of compromise. It is further stated by them that the memo of compromise has been duly signed by them. It has also been submitted that the parties now intend to live together. As the disputes between them have been amicably resolved, the terms of the compromise arrived at between the parties read as under 1, 2, 3 paragraph. In view of the compromise arrived at between the parties, judgment and decree dated so and so is set aside and the appeal is disposed of in terms of compromise arrived at between the parties. Give their signatures. Yes, it has been set aside. Yes, get it.
21, we go into that stage.
No orders are necessary to be passed on IA as the appeal is within limitation.
Husband's appeal.
Appeal is admitted for hearing record.
Permission. 22, we refer case, we will be cited for concerning.
Orders are necessary to be passed on IA 1 of 22. 1 of condonation delay as the appeal is within limitation. Oh, acha. Then you should notice 21, right?
21 years.
Not 11.
It's no delay.
No delay. This I 21.
It settles.
Acha,
20
this is
settled.
so this is password. 21. No orders are IA 1 of 23 admitted. Notice record.
22, refer case. Mr. Concerning.
Admitted for hearing. Notice record.
23, Bhaskar here, Rama here.
Admitted for hearing. Notice record.
24,
Appear for examiner.
Already notices. They are served.
Okay. So then don't say admit record. 24 admit record.
25, is invalidity or the fires up.
See them. Why?
Yes.
The temperature. Make a 24.
Temperature is 24. 24.
Yes.
Why the suit against Nilkan right who is also sending the declaration in the suit can be declared. Holiday is filed by the this is and in the delay not. Then you are watching it say according to that the bridge here is say here and the act is doing the day. So you are watching the point number 4 to 7. Why then a problem number 17 and 8 because the act even the current secret though it is not included last week by a problem. The case was registered in the year 26 of 78. So also, the appellant have also filed an application. I mean, given and it was dated number 1891. The merchant agency number 18 though there is the respondent 1 to 4 had filed a writ petition in WP number 24241 of 1984, and the same was lower than load the application filed by them, and it's one number 3 to 4, and the application filed by the rejected. Again, the petition is filed. The judge also dismissed the petition from that the date of filing of the petition by the petition. But are also of Washington see the election C. Election D. This to be like Washington. The fact of the suit will be by the jury loss.
Page 33 is not the total 33. 31.
The petitioner of the Rajasthan in the jury are in Sharma. Further, the resident of Tubigare is before point of the disputed land situated in Tammu Prale. It is not residing in Tammu Prale. He purchased land from Milkan. The petitioner Hiren Kumar tried they sued against him along with that's as per a it was a suit for accusation of crime and the decree was decided in favor of the jury. He prepared an appeal against the suit in Malaysia because this is on 6 times one more suit against this. Against which was a situation of it was also decided so these will be a waiting for judicial hearing and it was also decided not preferred anything, so it becomes final. In seeking against him and other people in that case, since he has not position of your. By 800. That same day, the lodging gets it, the same day, the first two benefits have been negated by both. courts. Also, it's this one, 3 to 4 centimeters. Spite of that, the lodging gets it, and then that single jack comes to the area, purchase the property. My application is quite delay. And for the cost of the unlikely of the finishing.
Where are the judgments where their sale deeds have been negative?
It depends on not produced. It's called.
Not produced.
But it is the observation, even they are not denied. One 3 to 7 are not denied for the judgment. And this order was not challenged by that. Unlike civil judge, you only look at because you have filed an application. We must take.
No, not something else also, not only that. Read para 12. Something else also about you.
The application filed by them is without any basis. Even as arranging the application page number 141 section present the cost of finding is quickly would indicate that the person the fix is indicated in English. Thereby, and I will have fixed the signature. Clearly debate the board when the material of the to indicate that there is an attempt on take arm faithfully belongs to the respondent. Here the logic is how is that the respondent is very to the because you can say it for the help of the environment.
All right, the appeal is admitted for hearing. Turn the appellant supports that the dispute between the parties is likely to be amicably settled. The praise for adjournment list after 2 weeks.
28 to the 6th of the year. The Sharad Gowda JP.
Appeal is admitted for hearing. Record. What are you? No case for grant of stay, first matter, right? No case for grant of stay is made out accordingly. IA 1 of 2019 is dismissed. What
He can be taken. notice.
you connected matter, you take notice, Mr. Connected.
In this case, respondent has to take. notice.
Acha, you, all right, all right. Yes. She accepts, all right. Write her name 28. Where you have said issue notice, no? Say notice on behalf of respondent is accepted by write her name. It counsel is so and so, office is directed to reflect her name as counsel for respondent.
39. We have a minute. And 50.
Yes, madam. R2. Reading R3 to R5. It counsel for the applicant. How much time, madam? Praise warrant is granted a week's time to enable her to file objections to IA 1 of 22.
Number 30. Vijay Kumar. Respondent.
Appearing for the petitioner's advocate, my lordship. I seek adjournment as the advocate needs to seek directions from the client, my lordship.
What, you are contesting elections, madam?
I am sorry about that, my lordship.
And thought that you are holding a press conference in the meanwhile. You have got some time, therefore you are appearing before us. Huh? What is
No,
this?
my lordship.
This is, can you appear like this in the court with something like what is there appearing in your background? Huh? This is court, madam.
I'm sorry about that, my lordship.
You are praying for adjournment, right? In any case.
Yes, my lordship. So after the elections, madam, this case, after you become member of Legislative Assembly, then we will hear this case. I'm sorry about this, my lordship, but I was appearing for the appellant's counsel, and this had to be done at the last moment. I'm really sorry about this. I seek my pardon on this, my lordship.
And so, for it, counsel for the appellant prays for adjournment. List after 1 week.
Much obliged, my lordship.
Huh? Which time? Counsel for the appellant prays for it is granted 4 weeks time, further time to enable him to use a memo reporting settlement.
All right, so you are ready. This has to be heard finally. Because you are ready. Yes, Mr. What is this, Mr.? Should we send an invite to you every time? He's arguing, he's saying, we are telling him. He's also not telling us. We are telling him because we have seen the order sheets. When the parties had appeared, they had undertaken that we will argue it finally, and we know that you are not ready. Where from you got this idea that we should do like this? Do you think he will take the whole day? They should tell us. No? It's we are as if every time we should keep here a live electric wire and press it instead of saying all this. Why to waste our energy? They will get automatically, they'll get shocks and stand up. Oh, that's what you should do. We should do properly. That's better. Here, a button for me and my brother. We will press it. You will stand up. When do you want? Yes, Mr. Oh, acha. All right. You are in outstation. Then yes, whatever. Which date you want? Which date you want? You are an outstation council. Will fix it. Fifth is Sunday. Monday. No problem. We can hear this matter today also. But you have learned, like you have seen how they are. Yes. 7. Whatever, give an agreed date. On that day you will argue, right? If AG is not there, Mr. And we will have that arrangement also in place by 7 February. Right. Mark the presence. 7 February, right? Learn it council for the 30 jointly pray for adjournment in order to enable them to argue the matter finally. Let the same be listed on 7th of February 23. Give a synopsis if Mr. To cut short, right? Because he is already referring to history, so therefore you should tell us what is the history. 2-3 pages. It will save time. Save time. Will save time. Yes. Yes. No, not here. Not a place meant for filing. Praise for adjournment. What to do? What you want to do? What? What do you want to file? All right. Learned counsel for the appellant prays for adjournment to enable him to file file an objection to the to the affidavit filed on behalf of the respondent as well as synopsis. When do you want? List up 1 week. How much time? List after 1 week. Or you can hand it over on that day. What's that? He wants to file it since, so we are permitted. So how much more will you pay? Out of 3, you have paid 1.2.
Proposal of some concession today. Pending. Payment of 2 crores. And you can say possible any amount below the
Of course,
That's what ultimately I have considered the part of it. They would be paying.
that not sufficient. Mark the present. All right. It's senior counsel for the appellant prays for adjournment in the light of observations contained in the order dated 21/7/2022, and to seek and to enable him to explore the possibility of amicable settlement of dispute, if any. List on what is next week? 7th February 2023. Interim order shall continue till next week. Yes. Record. Right. So same notice and record. This two.
Number two, one matter. Bhavan. Contempt. Yes, 40%.
Let this petition be listed on what date? Thursday. Thursday, what date? 2nd February.
But two. Number two, no contempt.
Come closer, not like this. Come here. Ah. 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 No, have you received the notice?
No.
Huh? Let-
And after. Payments.
Arey, Mr. No. Have you received the notice of this petition? No. Then how you are appearing?
Yeah.
Mr. It is you. Please understand. I mean, the record says that you have been served on 19/10/2022. This is the contempt proceeding. Be serious about it. Don't, I mean, it's not a public platform where you can say anything, right? This is a contempt jurisdiction of the High Court. Order sheet says that you have been served on 19/10/2022. There, despite notice of service, you didn't appear, therefore a bailable warrant. It's understandable that you want time to file reply to this, that we can. So last day, you were granted time to file objections on the last date. What happened? No, not here. There is a filing counter where you have to file, not like this. You will file it during the course of the day, right? So when should we take it up? Yes. What date?
And without any possible.
No, Mr. Yes, sir.
So, I'm an advocate. And how can you do this? He is trying to make a part of.
No, you are an advocate, therefore you understand proceeding, right? We thought that so far that you are not connected with this profession, but no. Last date of hearing, you were granted time to file a statement of objection. Why you did not file it?
No. It's state.
So tell us the next date. On that date, we will decide the case. We will decide it. We will proceed further, whatever has to happen. When party person present, he states that the statement of objection shall be filed during the course of the day. After supplying a copy of the same to learned SPP, SCGP, list on what date? Huh? 16th, list on 16th of February 23. On the aforesaid date, respondent shall appear.
Yes.
Huh?
Because there is no current.
And go, you are an advocate, right? You understand what is what. We have passed an order. Yes.
Number 3, the allocation I told her.
For 2 weeks. Weeks time.
Number 4, we Ramesh Babu. Okay.
Despite cost, if you are not this thing complying. It's further consideration, right? Let the contempt petition be listed on 2nd of February 23.
Okay. Government advocate.
We don't know. Compliance report. Compliance report. Filing review petition doesn't mean compliance. There is no stake. Then for a week. Direct counsel for the respondent praise for it is granted a week's further time. Enable him either to produce an appropriate order or to file a compliance. Huh? What date? 6th February. 20.
Number 6,
Same order. 7th of February. They will produce either, what is the order, either they will produce an appropriate order or compliance. That's it. 7th February it will come up. 9th February, right?
Number 7 is the government.
Office of after hearing senior counsel for the petitioner, office objection ignored, issue notice.
Number 8, Kumar Jain.
Yes. Live electric wire, madam. Huh? You are, reminding us that we should make arrangements for live electric wire, then only after getting mild shocks, you will stand up, right? He is telling, right, that the government who will take steps to ensure warrant is served. Need additional government advocate praise warrant is granted. It's time to enable her to seek instructions and to ensure service of warrant. Yes.
Attend. Vasant Advocate, government advocate.
Calling. What's the order?
What happened to 9?
9 is adjourned. AG had appeared. Okay. This one, this on prosecution. All right. Reasons assigned. 12, 10, 20, called. WP restored by get office object complied with within 2 weeks. Even further, let the same be listed. Let the same be listed. Report. Let the petition be listed 3rd of February 23. It's all for further consideration. Please appreciate. We can't take up item 12.
I appear for the petitioner,
This
my lord.
for further consideration on 7th February. 7th February.
Number 30.
Friday. Red counsel for respondent praise for adjournment. Why? On the ground that arguing counsel is not available. He therefore prays for adjournment just on 3rd of February 20. When you comply, nobody prevents you. Yes. You need our permission. No. Yes, do it. Yes.
Number 14. Ekal Pradeep Kumar.
Red counsel for the petitioner's praise warrant is granted. 2 weeks time. An application seeking substitution of legal representatives of deceased complainant.
Number 15.
My lords, I appear on behalf of the appellant counsel. The appellant counsel is held up due to personal inconveniences.
For adjournment on the ground that arguing counsel is not available just after 1 week.
Much obliged, my lords.
Number 16. Sri Abdullah Deo. Legal purpose, all advocate.
The red counsel for party jointly pray for adjournment list on 7th February 20. It's a why check interim order if any shall continue. Status. All right. So it will. All right. So we have said in. Yes. Record. But there is no order, right? Probably 7th. So you will do the, all right. It's voluntary. He's saying that it was there. All right. 7th. His statement, Mr. Mahindra's statement should. Right. Instruct them. 7th. We are not saying anything. Hmm.
18. Okay.
Ah, 7th February 23. Yes, he will instruct. Yes, Mr. Yes, madam. Don't say interim order if any. What is the urgency, madam? Yeah. Consider representation. Next week you argue before regular bench, it will be available, right? Let the writ petition be listed in the next week. It's 6th February, 7th. 7th of February 20.
Payment of charges, number 19. Mahesh,
8th February. It's on 8th February 20.
Continuously jumping the everything matter. Kind of, it is just a 2-floor. Garbage which has been accumulated is just like 2-floor. My entire property is being done. Because I have produced a photograph. I have produced a photograph.
It's for framing of charges, you will have to move some application. Please file an application for appointment of a court commissioner. Yes. As it is, she is not opposing. There should be no difficulty, right? File an application.
Next week.
8th February, it's coming up, right? Before that, you can file.
number 20.
Right, this was final hearing. List next week, final hearing. Agency. Thing will happen, you will get all the salary, right? Relieving means if you succeed, I mean, will you not get all the benefits? Why work and get, you should get money without work, right? Litigate and get the monetary benefits. Not day after Thursday. That's what the petitioner so and so. Right, counsel for respondent list on.
You appear for the appellant or respondent?
Respondent. 1 to 20. List on Thursday. What date, Mr. Mohan? Yes. Final hearing. Next case. Which date? Which date we are asking you? Which date? Next week? Monday, Tuesday? Okay. What? Which date? Nice. Mark the presence list on 9th of February 20.
Number 1. Legal matter. 36. And then. 2 weeks. Counsel for respondents, Mr. Suyog Derile and Mr. Lakshmi Narayan, learned government advocate for 3 and 4, pray for and are granted 4 weeks time to enable them to file statement of objection.
After having participated in the second round. The category that he applied for, he seems to have vacated legally despite the legal action. He serious joint medical. Wants to join medical, not. What's the one that also filed its objection, they haven't filed about that aspect. Which there is no dispute about that. The guidelines you have provided for a situation where I cannot do that. Reading down those guidelines and starting to violate.
So why you did not challenge before? You should have challenged it beforehand. No. Before appearing in the participating in the counseling, you should have challenged it. No. What we are trying to say that this instruction was there available when you appeared in the exam, when you knew beforehand. So why you did not challenge it? Why only after taking a chance?
But in the peculiar facts of this case, the seats were vacated only at the last minute. I wasn't aware that such could arise. That despite the threat of legal action, people who take permission would back out after getting the seat allotted. And
what is bad about it? They don't have any authority to frame this. What is it? No. What is the? So you are challenging the virus. What ground? It can be challenged on 2 grounds, right? What are the grounds? It's not there in the petition. What grounds it can? Validity of a provision can be challenged on what ground? It's not there in your file. Either you know it or don't know it. So what grounds it can be challenged? We are asking. Answer you won't get in your petition. Answer is in your mind somewhere here. What grounds you challenge the validity of a provision? 2 grounds. 2 grounds. Either the authority making the rule has no power to do so, right? And secondly, is violative of fundamental rights. So they have power. What's wrong? What fundamental right? Please understand, with reference to facts of a case, you cannot challenge the validity of a provision. What is, I mean, you are obviously trying to challenge it on the ground that it is arbitrary, right?
In a particular situation, in this particular, this is a widely prevalent situation. Even in this case, there are 10 seats which are opened up in this particular college. So it is not something.
No, supposing if 100 seats open up after the last date is over, what can the court do? Admit finality. There is something called attaching finality to the process of admission. If it keeps on happening, do you feel that, do you think, don't you know that it has a ripple effect, right? You will leave your seat, go to another college. Those students who are eyeing on your seat will, so this will never come to an end. It will go on till you pass the MBBS examinations.
guidelines to legal action. How doesn't talk about any legal action being. I mean, the state of court do those provisions. Then come back to my short point wherein my grievance line.
Admitted for hearing. Petition is admitted for hearing. To argue at length, why should we hear you out? There's no point. Any other counsel in your position would have said that it has become infructuous because no interim order has been granted. Since you are insisting on arguing, we thought that we have much older cases, 2015, why 2022, when you have not even started the you don't know what is the ground on which you are challenging. We will hear you at length, whatever after 5 years. No urgency. That's why. To save money, like that's what it is about. Correct. Look, you have an excellent case for admission. That's why it has been admitted, right? Admitted for hearing. File an application for re-hearing. We will consider, we have much older cases, right? Right. No, we have admitted this. By now, you should have finished the argument instead of telling us to do this and do that. If you knew the case, you should have concluded by now in 3 sentences. That is what is art of advocacy is about. You are still arguing and making us, we have admitted it. We will hear you at length, prepare it, and then come fight.
Pass over matter.
We tell you that on this ground, provision cannot be struck down. Last week's. We can't read down. Nothing turns upon this now. You can't get any benefit. Last date of admissions are over. We cannot do anything contrary. Argue. We have admitted it.
Mail settlement.
This number
Passed out.
Oh. How do we decide what is written? You will read.
It is dissolved.
Huh?
Dissolved.
No, you'll have to produce the terms, right?
Kannada.
So, it can be reproduced.
Yes.
Huh? Yes. Item number 4. Yes, mark her presence. This appeal under section 28 of appeal, which under section 19 of the Family Courts Act 1984 has been filed against the judgment dated 28th March 2016 passed by the Family Court, by which petition filed by the appellant under section 13 of the Hindu Marriage Act has been dismissed. Paragraph. This court had referred the matter for mediation. From perusal of the report submitted by the Bangalore Mediation Center, it is evident that the matter has been amicably settled between the parties. The terms of the compromise 4 to 11. Read as and done. Write in his lordship's name, right? His order. Lordship's name. Dictated by on. And then you have to, because it's all here. Paragraph 4 to 11. Quote, in view of aforesaid compromise arrived at between the parties, the petition is what we have allowed. Achha. The marriage between the parties is dissolved by a decree of divorce, and the appeal is disposed of in terms of compromise arrived at between the parties.
Yes.
For 26, SC Shivra, AV Gangadharappa, how many cases?
What, which case?
26 shift.
Aswad.
Short purpose.
Yes. Yeah, but what to do? We are asking you for a solution. When a junior counsel appears and seeks a passover and disappears, what this court should do? At the moment we dismiss it, he will come rushing. He also knows what is eventually is the fate of this case. But the problem is we dismiss it, he will come rushing. What to do? Tomorrow then. None for the appellant, even when the matter is called in second round, mark his presence. List day after tomorrow. It is made clear that in case no appearance is made on the next date of hearing, appropriate order shall be passed. List on whatever day after is what? 1st February 23.
Pagari, Jagdish Piti, Revata Pallavi.
Huh?
You contact the other side. Did you contact the other side? You could have called him over phone.
No, despite knowing that he practices in Davangere, you tried to contact him physically by going to Davangere. Huh? What? What? You have got the number, right? It's a case where you have been convicted for an offense under section 307, right? Or pending. Criminal case is pending against it. Attempt to kill your wife. Huh? And you want a divorce on the ground that she is cruel. Huh? Interesting, no, Mister? A criminal case again, you are facing trial for an offense under section 307, and you say that your wife is cruel. Interesting, no? Huh? Huh? Cruelty. So what did you do? You dealt with her very gently, huh? By committing 307. Oh. Huh? What did you do? What is the allegation? What did you do? Tell us. What? What did you do? What is the allegation? What did you do? You must have read it, right? What is the allegation against you? That's what we are asking. What? So that's why we are asking, what did you do? No, we are just being inquisitive. That's nothing. We are being curious. So just you have read it, right? No. What is it? You tell us. Just What did you do?
Lordship is asking why 307 is invoked. What is the allegation? You can't you tell in one word, why is 307? How? Attempt means how? What is the allegation? Sir, allegation is of strangulation. Fact is that you have not read. That is it. We have seen it.
On that day also, you were thoroughly unprepared. You said that I'll come ready. Today also, I mean, same. Huh? So basically, the court has to do whatever, I mean, right? So you tell us tomorrow, you have got the number of the other side. And don't tell us tomorrow that I have not been able to secure the number of other side. Don't tell us tomorrow that I have not been able to secure the number.
Where will you get it? It will be there in the wakalat.
The number, right?
If it's there, you write on it.
Not mentioned. You don't give it. You said it should get there. Yes, ma'am.
Whatever, tomorrow is the last day of this case, right? So what we are trying to tell you is tomorrow we will decide it.
So, say number 9.
Pastoral matter, number 19, Dr. maybe.
So, yes, what vacating stay? We have what is the stay? Are you doing? Huh? That means, I mean, before drafting the application, you have not even read the interim order. Amazing, Mr. Really mind-boggling. There is no stay of judgment and decree. That's why we, in the first round, we asked you, do you want to get remarried? You said no. The judge, stay is only with regard to dissolution of marriage. What, I mean, what should we do? I mean, you don't read the order, you draft the application, come before the court, then court should explain to you. Third, learned counsel for respondent, no ground of vacation of interim order dated 11/4/2022 is made out. In the result, IA 2 of 2022 is dismissed. So, responsibility.
Number 39, Common Advocate, M.S. Chandrasekhar.
Are appearing in 39. You passed an order, right? Dismissed. Application has been dismissed. He didn't say anything.
Common Advocate. Password. Number 40, Yardi Chandrasekhar.
Here.
Malad, I represent the respondents in this matter, Malad. But on the last occasion, Malad, they have proposed certain settlements, Malad, with regard to the husband and wife dispute, Malad. So far, they have not come forward with concrete conclusion, Malad.
40.
On the last date when the matter was argued, you were not here.
Malad, my colleague was present, Malad, he was not present.
Nobody was here. It is that on that reason he is present today.
I'm sorry, Malad, my presence is kindly be good, Malad.
And they have given a settlement proposal. You are not there. That's yeah.
Malad, I was under the impression that Malad, they are going to settle because Malad out of the court, Malad, they proposed this settlement, Malad. Therefore, Malad, I was under the, my colleague was present, but Malad, he could not represent.
The last date matter was argued by the appellate's counsel. They said they are ready for settlement. You or your colleague, nobody was here. That's why we have kept it
Malad,
today.
Malad, kindly accommodate at least 1 week, Malad, I will give concrete decision in this matter.
It's a part-time matter. There is no question of.
True, Malad, true, Malad. True, Malad. I understand.
Otherwise, we proceed on.
Malad, at least 2 days time may be granted, Malad, on that day I will. Second or first or second may kindly be have it, Malad. On that day I will submit before this formal court.
So, posted for further hearing and you don't even appear before the court even today.
Malad, sorry, Malad. Since I was unwell, Malad, I could not present. That's why, Malad. Otherwise, I was no intention to become absent before the court. I'm sorry, Malad. Day after tomorrow, may kindly have it, Malad. I will come.
Learned counsel for respondent prays for a short accommodation. Let's go further. It is made clear that no further adjournment shall be granted. List on day after is what? 1st February 23.
Please. Great.
Finally, 41, E. Ravindra Prasad, M.S. Raghavendra, Aditya Narayan, Government Advocate,
Yes.
A. Kumar Patil.
When do you want? Tell us what date. You tell us the date which week. Yes. 13th February. Learned Counsel correspondent, place for adjournment. Huh? All right, Mr. Vijay Kumar Patil, Learned Counsel for respondent. Number 325, right? 41, 325, place for adjournment. Just on 13th February 23. For that, this could be decided today. Would have ordered it and then said no.
Number 42, government advocate, the case Srinivas, the Padmavati examiner, BJ Soumya. Government advocate.
17B. Received the amount, complaint. What? Then it's a writ appeal. It makes difference, right? When you say writ petition and writ appeal, it makes a difference, right? 1,50,000 compensation.
Industry and there is no positive evidence.
What is this Pratham Singh? Pratham. Where is the earlier decision? So like this case, the point is clear. What is it not an industry? Just tell that. That's why it is used. So who appears for respondent? No. I mean, like the learned single judge holds that forest department is not an industry, right? That finding is not under challenge at your instance. Challenge? You have also challenged. Oh,
42.4 is it?
all right. Then we. So, Mr. So which is the first decision, Mr. Tell us. So your case is simple, right? That what simple? No. What simple? You said immediately, yes, we want to know what. No, as we have understood your case is that once having recorded a finding that forest department is not an industry, the learned single judge would not have directed payment of compensation, right? So now you tell us, because they have also filed an appeal. So what is your version? This finding is under challenge. It's not an industry. So what is the first decision? Like this. No, decision on this legal position. 96. First one.
Scheme. Recreational purposes. That has been distinguished second case.
So where is that? First come to that 96 judge.
P.
So undertaking a scheme is not part of the sovereign function, therefore not a. So what is the ratio of the judgment, Mr.? You are not.
Appointment was considered. He was appointed as a daily wage. The appointment. Fine. Appointment is the. How many days is scheme? And so the forest department does not follow the lead. That's of this case, you know. That's of the present case. Same petition filed before the labor court. It's a big page 53. The attention of the department is the daily wage. That's of this case, not the attention to the. Therefore. This year.
Yeah, what is Maruti Kundari?
Daily wage. So. Very plain. Payment before the labor court that they were appointed as a. In none of the cases, each case, there is no evidence that they were appointed in this scheme. Therefore, any of the other. Ratio pharmacies of the.
There is no other judgment of the Supreme Court saying that it's an industry. What judgment they are placing reliance? No, no direct decision saying that it has been held. Understand, right? Understand. This case, Supreme Court has said no, in Pratham Singh, it has been held that forest department is not an industry. Any other decision of the Supreme Court holding that it's an industry? They, by an interpretative process, they are trying to. That's it. Anything else? No. What is the, according to you, what is the issue involved in these cases? So they are claiming regularization. Then what is the issue? They are not seeking regular. But still, if you want to cite, we can't prevent you. So, Madevi, if you want to cite it. Risk of being thrown out. Of course, sir. When you drive a vehicle, you know that accident can happen. Like that. Yes. You are appearing in this case, first case.
That's why the respondent, you have to hear the appellant. The respondent in second matter, you have to hear them.
Well, who is Mr. K. Srinivas? Mr. Srinivas, your case. You want him to argue on your behalf also?
Eight zero five.
805 ಅನ್ನಲ್ಲ.
054.
Your case, Mr. 56. So, your appeal. So these 42 and 42.4 are connected. Yes. Same order. Fine. Yes. So what? I have regular part. If I want regular part, what happens to this judgment 2001 volume 9? Not applicable. Why? No, you are engaged as a forest watcher. In the forest department. Then, so how this finding is incorrect? That forest department is not an industry, right? I have worked in the
the plant are being grown and the kind of being farmer. And there was not yeah, the clarification. The evidence brought before the which judgment says social forestry is industry? And what is the first of all show us what is the evidence to show that you are not an employee of forest department and social forestry? You are trying to say that social forestry is something different than forest department, right? Huh? The function of the forest department not problem. Plants were being sold. No, but there must be some must be covered. It's not for the first time you are arguing, right? So what is it? Judgment? You said.
வெங்கடேஷ் சுவாமி நடந்து வர இப்படியே டைரக்ட் ஃப்ராட் பண்ணிட்டு
Which judgment? But the learned single judges recorded this finding that admittedly you were employed as a forest watcher in forest department. When a forest, this is also an admitted fact. How can you now wriggle out of it and argue something else? So the next question is that supposing if we accept that it's not an industry, then all this could not have been done 1.5 lakhs and 9% interest, right? You agree? So therefore, I mean, if according to you, if social forestry is an industry, then you are entitled to restatement with full back wages. You should say full back wages. Why 50%? So that, yes. No. For arguing, we are telling you, you can argue anything. So, therefore, restatement with full back wages. It's not according to you, not a sovereign function. Therefore, full back wages and reinstatement with full back wages. Right? That's it. Yes.
That's it. Next 42.1. Forty-two point one. 805. So, and which is the other connected appeal? They arise out of the same judgment. Same judgment. No.
This petition was dismissed. Petition is dismissed.
Dismissed. Where is the averment in the claim petition that forest department or its activities they are carrying it's an industry? See, Mr. Madam Learned Singhal has said that it has to be decided on the facts of each case. You have not led any evidence. The common issue doesn't mean anything. That what is the evidence led by you? What is the averment made in the petition? Tell us. In the facts of this case, Learned Singhal has recorded a finding that there is no material on record to hold that it's an industry. No. First, point out what is the material available. What is the this thing averments in your claim petition? What is the evidence to show that it is an industry? Read para 16 of the order if you don't understand. Read para 16 of the order passed by Learned Singhal. What does it mean?
Since case,
Which is 16, para 60. That merely because read further. Nobody is saying that. When it will be 25F applies to High Court also, Supreme Court also, courts also everywhere. It will apply when industry, right, madam? What have you read? What have you understood? I don't think there's any point in argument. All right, thank you. That's it. Ah. Hmm. Unreported case. Huh? What is this? There are several judgments. We will not take it, madam. If you throw it on our head without referring to paragraph numbers and etc., we will not take this. You have not read what is which paragraph, what is the ratio, nothing, and in the garb of one judgment, you are just giving us 10 judgments. It's not our job. We have asked you the answer to paragraph 16 that you have not told us, and you have passed on these 10 judgments, and we will not refer it to it because you have not, it is not our job to find out the ratio. What is it? Right? Thank you. This is the level of assistance when your client has to thank himself for invoking you. Right? One, dismissed your petition. Yes, appeal is dismissed. Next. Yes, Mr. 42.2. Huh? What happened?
same like 42.2 is same. Or as 42, 42.2, 1.25 lakhs. 9%. Same judge, right? So in that case, you didn't tell the judge that in one case he had granted 1.50. So why? Huh? Should have been fairer by telling him that one case he has granted 1.5. Huh? Can see that lady is what to do. Have you gone through? You have supplied the case law compilation. Madam, case law compilation you have supplied to government advocate? No.
So much is
Huh? Huh. Sir, just a minute, just a minute. Or how do you meet this thing, these bunch of judgments? Will tell us, madam. We are telling you it's not our job to find out ratio decidendi of the case. You are not even prepared to tell us what has been held. Such a pity. Such a pity that the whole burden is on the judges. Then don't call yourself equal partner in the administration of justice. Don't call. If it is our burden to do justice, don't call yourself equal partner in the. You are not even prepared to tell us what is the ratio. We asked you. We said that we will not find out the ratio decidendi. Despite that, you have not told us. My brother is finding out for you. Really? Here is something you should be made president of India. What I mean? Or a judge in the International Court of Justice. Why confined to Bangalore? Anything. So, Mr. Say. So what? Yes, who appears in 42.2? 2. Yes. Yes.
Working as daily wage
Ah.
not working against the country is an admitted fact by the for the government. Yeah, it is at page 29.
That doesn't help, right? The law is against you saying that forest department is not an industry. So therefore, the submission is that after having held that it's not an industry, the learned single judge could not have awarded compensation.
It's
You have not filed any appeal against this judge. Then that finding binds you that it's not an industry. So therefore, the only question is whether after having recorded a finding that it's not an industry, the compensation could have been awarded. Obviously, would not have been awarded. That's the argument.
and so the then and from the I think payment of compensation in view of statement as in identical in WP number 5180 where the 10 9 WP number 186
The judgment.
Forest 1,50,000 of granted. Reason being since the loan of equity is from 83 to 87, they have worked.
They have not challenged this order. Hey, Mr. Find out this order in WA, what happens? This order has been challenged further.
It's implemented, what he said. Mentioned there. Oh, already they have deposited their amount.
Just a minute. You see, Mr. Give it to the government advocate, that order in WA.
That one.
1 minute. Wait. So in other cases, you have implemented. How can you be allowed to pick and choose, Mr. You are a state, right? Some cases you make payment of compensation, some others you challenge. See that order. It's recorded there that you have already implemented, and that's why writ appeal has been dismissed. So why we should entertain this? Your see that order. Don't ask us.
Last line, it is written that you have deposited the amount.
Right.
Yes.
Negative equality? What negative?
That case, then,
That's a negative equality. He did not deserve despite that you deposit. What are you arguing with? Strange. Sir, how can you pick and choose, right? In cases of some other employees, you have implemented the decision. And in some others, can you file a writ appeal? That's the question. Not negative equality. Negative equality concept does not apply to the orders passed by the court. Routine treatment applies, right? So why we should not dismiss when your similar appeals have already been dismissed? That's the question. Litigants are entitled to parity in treatment at your hands or not. That's how can you pick and choose in cases of some other employees you have deposited? In their cases, you are contesting the litigation. That's it. That's the order. We should not go into this.
These are the two, three benches are-
Okay. Order. All right. Goes your. So it's all concluded, Mr. by division bench. There's no this. We are not going to that question. Yes, give it. That it binds us. End of the matter. Yes. Yes. Huh? We are not interfering. This order of division bench, right? Your case also compensation is granted.
No.
Consider your case separately. Madam has unnecessarily got your case tagged. Huh? Obviously, you don't sail along with them. So up to 42.4. Yes. Yes, madam. It is 42, Mr. 540. 1630. 1630, 42. Wow. Then 1792 bar 2014, then 42.1, 42.2, 42.3, right? First give this ordinance. Okay. 160. Give one after the other. Yes, 1630. Right. These intra-court appeals. In these intra-court appeals. Twin common issues arise for consideration within bracket number 1, whether Forest Department of Government of Karnataka is an industry. Secondly, number 2, right? Whether the learned judge heard in holding the employee to be entitled to compensation in lieu of reinstatement and consequential benefits. Like tweet questions arise, namely so and so 1 and 2, comma. Therefore, the appeals were heard analogously and are being decided by this common judgment. Paragraph. The paragraph. The respondent in WA number 1630 bar 2014 was employed as a forest watcher in Forest Department. Full stop. Delete in all the cases, right? Delete the paragraph. The facts giving rise to filing of this appeal briefly stated are that respondent in WA number 1630 bar 2014, comma, appellant, comma, respondent in WA number 1558 bar 2014, and the appellants in the remaining appeals, namely WA number 8054 bar 2012, WA 1728 bar 2014, comma, and WA 1792 bar 2014 were employed as watchmen in the department, in the forest department in the state of Karnataka. Full stop. They served as such for a period from 1999 till 2003. For a period from 99 till 2003. 1990 till 2003. However, their services were terminated without taking recourse to the procedure prescribed under without taking recourse to the mandate prescribed under section 25F of the Industrial Disputes Act 1947. Full stop. Full stop. The dispute was referred for adjudication by the labor court. The labor court by an award directed restatement of the respondents in WA number so and so and appellants in WA number, right? You have got it. Huh? So and so. Along with 50% back wages from 31st of March 2003 until reinstatement. Full stop. The said order was challenged. The writ petition by the appellants in WA number 1630 or 2014, WA number 1558/2014. So, the state government, you delete state government in a writ petition. Full stop. The learned single judge, by orders passed on different dates, by orders dated, the learned single judge, by separate orders in the writ petition, by separate orders passed in the writ petitions, inter alia has held that Forest Department of the Government of Karnataka is not an industry by placing reliance on decision of the Supreme Court in state of Gujarat versus Pratham Singh. State of Gujarat versus Pratham Singh. This is the 2001 volume 9 SCC, right? Full stop. However, the learned single judge, taking into account the services rendered by the employees, has directed the state government to pay a compensation, a lump sum compensation of rupees between rupees 1.25 lakhs to 1.50 lakhs within a period of 3 months. In default, the state government has been directed to pay the aforesaid amount along with interest at the rate of 9%. Full stop. In the said factual background, these appeals have been filed by the state government as well as by the employees. Paragraph. Learned additional government advocate submitted that the learned single judge, after having recorded a finding that the Forest Department of Government of Karnataka is not an industry, heard in directing payment of compensation in lieu of reinstatement and back wages. On the other hand, learned counsel for respondents have learned counsel for the employees have submitted that in fact the learned single judge ought to have directed the restatement, ought to have maintained the award passed by the labor court. Paragraph. Ordinarily, we would have adverted to the rival submissions made by learned counsel for the parties. However, in the peculiar facts of the case, we refrain from doing so. Full stop. It is pertinent to mention that a similar orders passed by learned single judges of this court directing payment of compensation to employees of Forest Department in employees of the Forest Department of Government of Karnataka instead of directed payment of compensation, in lieu of reinstatement. Have been upheld by various division benches of this court, and the appeal preferred by the state government has also been and the appeals preferred by the state government have been dismissed. Full stop. The details of the cases, details of the writ appeals are as under, right? You write number 1, judgment dated so and so, passed in WP number so and so, and give parties name versus so and so, right? 1, 2, 3, 4. Paragraph. It is not in dispute that the directions issued in several other cases by learned single judge have been implemented by the state government. Full stop. In order to maintain parity and in view of judgments rendered, aforesaid judgments rendered by division benches of this court, which are binding on this court, comma, we refrain ourselves from examining the issues in these appeals. The question of law race is kept open to be agitated in an appropriate proceeding. Line below. Accordingly, the appeals preferred, namely WP number WA number 1630/2014 and WA number 1558/2014 are dismissed, whereas three other appeals are disposed. So appeals in WA 1630/2014, WA number 1558/2014 and WA number 1792/2014 are dismissed, whereas WA number 8054/2012 and WA number 1728/2014 are disposed of. And 42.5, let this appeal be delinked. WA number 1630/2014 and be listed separately for. Achha. So we have to. Achha. So then WP number so and so, which other two appeals, right? WP number 808054/2012 and WA number 1728/2014 are allowed. Are allowed. Also, we are awarding compensation, are allowed. The judgment passed by learned single judge. Judgment passed by learned single judge dated. Judgment dated so and so and so and so are set aside. Order dated so and so. You see, learned single judge are set aside.
Yes.
Are modified. Are modified, and the and a compensation of 1 point and the respondents are directed to make payment of a sum of rupees 1.50 lakhs as compensation within 3 months, failing which the amount shall carry interest at the rate of 9% per annum. This statement, which my means which case, Mr. There are 5 appeals listed. You say my. Huh?
In all the other matters, we have granted compensation. That's no exception is made in your case also. Earlier judgments, you probably have not listened to the judgment. We have left the question open.
We have referred whatever. I mean, if you after dictation of judgment, you want to argue, we can't help it. Fine. Something called like parity, we can't, I mean, in your judgment case, pass a different order, in other remaining 3 we cannot, right? We have whatever we had to say, we have said it in the judgment. Get the copy, go further. Yes. This is what is the effect of not arguing the case. What can be done?
43.
So give it in white sheet. Huh? Give it in white sheets. Huh? What is it? I mean, we don't know. What are the facts? Possession not taken. We had given synopsis. Who have filed? Where is it? What you have taken possession? There is a mahazar, but you have not issued a notification under 16(2). And in that mahazar contains the signature of the landowner. Yeah. Larson and Tubro.
Equation may not lie. And once the equation is completed, the land cannot be put back to the landholders. You can utilize one from other.
Maybe we don't remember, and we will have to. All right, we'll continue after the break. 2:30. Yes, yes, please. Go ahead.
Yes.
What? Okay. ಇದು ಇಲ್ಲೇ ಇರ್ಬೇಕು.
ಈ ಫ್ಲೈಟ್ ಕೊಟ್ಟಿರ್ತೀನಿ ಏನು 2:30 ಆಯ್ತಾ ಹರಿಯ ಈ ಫೈಲು ತಗೊಂಡ್ಬರ್ಬೇಕು ಹಾ ಮೈಕ್ ಒಂದಂಗಾಯ್ತಾ ನಮ್ಗೆ
Meeting is over. The thing that meeting is on.
So, Mr. Yes. So first submission is that in WA, finding is recorded that scheme has lapsed. Which paragraph? Violation. Can be both, Mr.
Equal.
Yes. Yes. 13375, what is the finding? In respect of other survey number 83 and 84, the finding according to you is that it has lapsed. All right, where is? All right, so tell us where, which judgments? Yes. First one is 13375. This is about which survey number, Mr.? Survey number. Same village. The same village, right? Survey number 179 of same village where appellant's land is there. Or different village.
Number 179 is the present case.
Mr. Survey number 179 is the present case. No. 13375, you got it, Mr. Which survey number? 83 and 84 of. All right. So where is it? This scheme has lapsed, right? Which paragraph? Thirteen. Para 7. Yes. Page. That is in WA 435, right? 435 of 17 it has been. Page 42. Which judgment? Which judgment? No, what about this 24302? Third. WP. Hmm?
435 arises from first.
Hmm.
435 arises from the first order.
Oh, first. What this document number 3-4? What is it, Mr.? Please tell us. You are not referring to it. But which similar means in respect of which survey number? 24302 is survey number. All right. So then, what is document number 4? WA116 is the order.
It is the very same order.
Which page you said? 59. Ah. Yes. No, this is tell us. No. This is in which survey number? Which village? Thoroughly. A survey number? But yours is a different village. No. In your case, you must have read learned single judge has recorded a finding that whatever the land was available free of litigation in respect of that land, BDA has implemented. That's the finding. You will have to meet that. That's the finding. Whatever, see, section 21, we cannot envisage a situation where this court has entertained a petition, granted interim order. Then you can't invoke section 27, right? Your case also interim order was passed in previous rounds of litigation. When your father had filed a petition, then interim order was there or not? It was there in earlier round. So already, so we have understood that in respect of lands in Uttarahalli village, it has been held that the scheme has lapsed under section 27. That finding has been affirmed by division bench. In 3 other cases, apex court also. Where is that? Where is that order? Compilation you have given. SLP. All right. Which order in SLP? 92. This is against which order? (435). WA 116 of 21. Writ appeal 134. So finding is, what could be argued against you is that finding is only in relation to petitioners of that case, and in respect of land held by them, that scheme has lapsed. We don't know. They may argue that it may not inure to your benefit.
They have not followed it even as of 2005, not even in the 75. As a mainland expensive even.
So all right. So we have got it. First submission we have got it now. Yes. What is the second submission? Possession not taken. Government says in statement of paragraph 4 of statement of objection. Para 4. Para 4 of statement of objections by the government, right? Para 4. Hey, this you can't do it for the first time, right? You have to put them on notice. Have you filed along with an application, please don't. Mister, you have been given a copy, you know about it, joint survey. You don't have any objection to this being taken on record? All. Or joint survey? When it was undertaken, joint survey. Why don't you file everything together, one after the another memo? It becomes so difficult to handle. Today itself, you have given 2 memos, today itself. Previously, 2 memos. So 4 total, separately. No, it's all right. Yes. What is the date of this survey? Mr. This not even with an affidavit, how can we rely on this? Not even like memo, nobody owns the responsibility, right? If this document is something. All right, but he is agreeing to it. You are agreeing to this document. What is the date of this thing? 13/9/2005 joint survey. Adjoining lands have been denotified. That's it. You should have taken you are agreeing to it. What can be done? All right, so adjoining lands have been denotified. What else? Mr. But please appreciate this. Your father was granted the liberty to challenge the final notification, right? He did not challenge it. Then that eventually an award was passed. Subsequent cause of action. And what is your submission on this argument that in the facts of that case and in relation to that land, it has been held that this scheme has lapsed and the learned signature has recorded a finding that wherever the land was available, the scheme has been implemented. Therefore, your submission with regard to section 27 has been repelled. Yes. Oh, yes, yes. Eight.
Yes.
Therefore, they cannot follow the level only in this four acts. I he would find. Still, that is in general applies to the land, all the villages. That is because the 1,480 acres or 85, and you are now in a residential. Yellow is not possible. That means not even a 10%. It's not only substantial implementation, and therefore it will be 70. Two questions. Yes, regarding the equation. Second is not that two points. The equation is concerned whether the first final notification was issued on 9/9/90. This notification was
No question.
challenge question. Thereafter, whether the one more notification by the father of the petitioner.
We told him he is not, those facts are not disputed that his father filed two petitions. Final notification issued under section 19 has attained finality. Award has been passed. He is only solely on the ground of section 27. And you have to tell us two things. First of all, possession has been taken and section 27. So what is this Mazer dated?
After section 16 of the land acquisition act.
Mazer dated Mazer
Mazer dated 27/3/99.
27/3.
99.
Signed by whom?
But it is signed by the revenue inspector of land acquisition. There are panchas.
Land acquisition officer.
Revenue inspector of special land acquisition. And 5 panchas.
So now what about section 27, Mr.
27 this case is concerned. After the acquisition started, we have notified the invited the tender of the layout. By that time, they have filed this petition and take the stay of the tender notification.
Wait. When stay?
Stay is
So when were the interim orders passed in read petitions filed by his father? So what's your case that it on account of interim order, this scheme could not be implemented?
by that notification was challenged in the present petition before the next single judge. Therefore, we have.
So when was the interim order granted? Huh?
Okay, Mr. Nataraj. Record of the writ petition. Can you get it? Get it? All right. So
We will take the video from party of the level. The earlier whether the repetition is concerned of the senior produce the judgment, where then all the repetitions and retakings are covered, the dispose of following the judgment passed in WP 374 of 2013, whether it is page number 7 of the compilation. That was portrayed in all the things that repetition was allowed, it was followed in the other repetition. In that is page 17 of the first judgment. Page 17 of the para 9 page 17 compilation. In that view of the matter, not only the scheme was slab, but even the execution can be said to have a slab in view of no further action having been taken by the BDA pursuant to the notification issued by the informing of the layout. But finding of this can be, then the finding whether consequently the petitions are allowed in so far as the petition's land is concerned, the scheme is declared to have that in view of the disposal of the petition. So only though that particular land is concerned, the petition was disposed as a lapse. That judgment is attained finally to Supreme Court. The rejected as well as the Supreme. Therefore, one of the land question is concerned, since there is a hurdle to form the layout, the layout formation was stopped. Therefore, as written in the Krishnamurthy's case, one of the layout in the region, Krishnamurthy's case, they said if there is a hurdle, then the scheme cannot be as a lab. That too, in judgment, lapsing of the scheme, they have to come before the court within 5 years from the date of the judgment.
which paragraph?
Says, moreover, that a period of 5 years lapsed in the year as to why the petition for 7 years in understandable.
So in this case, when 5 year lapse?
But here the notification is the year 1997. 2097, 5 years. 2002. So repetition was filed in 2008. Delay is concerned, another judgment there, Development Corporation, page 16.
Hey, that's all right. When nobody is challenging the land acquisition process. It's only section 27.
Judgment, the para is the answer. They cannot come after the statement of the.
Not come. What? Please read what relevant.
Para 5. Moreover, that period of 5 years lapse in the year 1980 as to why the petitioner applied kept quiet for 7 years in ununderstanding. However, the learned counsel for the appellant sought to argue that there being no immediate threat to dispose that he did not approach this. The explanation will not scare the appellant, or because there is a extension of the land and steps taken being taken.
Yes. So what? All right. What's next? Which judgment? Other one.
The other one regarding the
Banda development is delay with regard to challenge to the land acquisition process.
second is delay. Challenge.
No, it's not.
But they cannot come.
He is not challenging. That is already a land acquisition proceedings have attained finality. There is no doubt about it. Yes. Third, what Chandrasekharan?
Chandrasekhar is. There is para 25 to 31.
What is it about?
Once the land is vested with the state government, they cannot be divested to the.
He said no, land vest only on issuance of notification under 16(2).
The 16, the section says, 16 may issue section 16, and 16 is not necessary when they.
16(2), Mr. doesn't deal with vesting. It only says if a notification is issued, it shall be a proof that possession is taken. Prima facie proof.
16(1) is sufficient. 16(1) is sufficient.
16(2) does not say so about vesting, that only on issuance of notification. 16(3), is there 16(3)? Does it say so? All right, we'll come to it. Yes. So what else next?
The Chandrasekharan's case is concerned.
Ah.
I start from para 25 to 31, but I leave one para 29 minutes.
What is
it? That if the land is required for public purpose, after the public purpose was issued, the rest of the land could not be used for any other public purpose. In case there is no other public purpose for which the land is needed, then instead of disposal of the, by way of sale to the owner, the land should be public auction, and the amount fetched in the public auction can be better utilized for the public purpose envisaged in the directive principles of the Constitution. So the land of that paragraph says even cannot be divested. The property is once vested. That next judgment where the return bench of this scheme is the very same scheme as implemented.
which judgment?
Page unreported this is page 48. Start from 48.
Scheme implemented. Which paragraph?
The paragraph 25. The page is
(64).
As far as the contention regarding the applicability of the section 27 of the Act is concerned, it is noted that the set provision states that within a period of 5 years from the date of the publication of the official gazette, declaration under section 19 of the
All right.
Act has to be exercised.
Fine. You are saying that even if scheme lapses, acquisition survives.
Yes, that
Offshore holdings. All right. Which paragraph?
38 and 39.
That's it. Anything else?
Therefore, in respect of the land in question is concerned, the prevented from implementing. Therefore, it cannot be done.
Offshore, which paragraph?
38 and says also once the land is acquired, not be.
Who has initiated the acquisition proceeding? Who had initiated? Acquisition proceeding was initiated by whom? Who did? Who carried out the land acquisition proceeding? Huh? Government? By the BDA, right? Huh? So how do you say possession not taken? It's for authority to say possession taken or not. You are in cases where you are party and we ask upon you to tell us whether or not possession has been taken, you are fumbling. And in the cases where the authority should say that whether or not it has taken possession, you are coming forward and making a statement. Why should you say so? That possession has not been taken. Should we call for the person who has sworn in an affidavit? What basis he says? When BDA is saying that possession has been taken, we may accept it, may not accept it is a different thing. How can you filing a statement of objection in the case where not required? And in cases where we are asking, you are saying that no, you have seen in the morning session that we will sink or swim with Karnataka Examination Authority, right? Yes. There you are not. All right. Yes, Mr. All right.
Therefore, the statement filed by the government is correct. Question will be taken by the government, not by the BD. After taking question, it will be handed over to the BD. And another issue, the judgment cited from the Minister 2012 Supreme Court. It is the application and then the land acquisition. But the land acquisition, the government acquires the land and question is taken land west. The government may not use the land for the particular purpose, it can use it for any other purpose. Here there are two phases, daily function and in law, that is not daily. There is nothing not applicable as a people.
What does it say? Yes. It's 110. Yes.
Now we can respond to in the between other scriptures and the release. Don't notice anything.
Give that record, Mr. Right down. Learned senior counsel for the appellant. Submissions, right? Whatever I dictated previously. So in the aforesaid factual background, this appeal has been filed thereafter. Learned senior counsel for the appellant submitted that the scheme has already lapsed. It is further submitted that aforesaid finding has been recorded by learned single judges of this court by order dated 2/2016, 24/2020, and 24/2020. not an 24/2/2020 white orders. No, the aforesaid the learned single judge of this court white orders dated 2/2/2016 and 24/2/2020 passed in WP number 13375 bar 2013, WP number 24302 bar 2018 and WP 32605 bar 2018 has already held that the scheme has lapsed. It is further submitted that aforesaid orders have been upheld in an intra-court appeal, namely in intra-court appeals, not an in intra-court appeals, namely WA number 435 bar 2017, WA number 116 bar 2021, and WA number 134 bar 2021. It is also pointed out that aforesaid that the orders that the judgments of division benches of this court in the aforesaid 3 appeals have been upheld by Supreme Court, by Honorable Supreme Court, as SLP has been dismissed by order dated 12/10/2022 in SLP number 19776 bar 2019 and other connected matters. It is contended that while inviting the attention of this court to averments made in para 4 of statement of objections filed by the state government before the learned single judge, it is contended that possession of the land in question has not been taken. Full stop. Our attention has also been invited to a joint survey report dated 13/9/2005 conducted by the officers of the authority, and it has been urged that adjoining lands have been denotified, and therefore the authority cannot form a layout on the land of the appellants. Full stop. It is also contended that only 10% of the lands which were notified for acquisition have been utilized for the purposes of formation of layout, and therefore learned single judge ought to have appreciated that the scheme has lapsed. The scheme has lapsed in view of Section 27 of the Act. In support of aforesaid submissions, reliance has been placed on this issue. These judgments and this WSO and so Banda Development Authority, Bondu Ramas. On the other hand, learned counsel for the authority. On the other hand, learned counsel for the authority has submitted that has produced the record pertaining to acquisition of the land and has pointed out that a mahazar has been drawn on 27/9/1999 and the possession of land in question has been taken. It is further submitted that the challenge that the land acquisition proceeding which has culminated in passing of the award and by taking over of the possession has attained finality. It is also urged that it is contended that when the authority invited tenders for formation of the layout, the appellants filed the writ petition namely WP number so and so, from which WP number, whatever order is there, WP number 19739 of 2001, in which from which this appeal arises, in which an interim order was passed. Therefore, the authority was unable to take steps, unable to implement the scheme in respect of land in question. It is also urged that that the provisions of Section 27 of the Act do not apply to the fact situation of the case. In support of Forces submissions, reliance has been placed on decisions on a division bench decision of this court in Krishnamurthy versus Bangalore Development Authority, ILR 1996, Karnataka 1258, as well as decisions of Supreme Court in so and so 3 cases. This one, this, 4 rather, 3 and 4. Learned counsel for the authority continuation. While referring to a judgment dated page 48, judgment dated 3rd of June 2021 passed in WA number 391/2019 has contended that a division bench of this court has already held that the scheme has been substantially implemented and the contention implemented. That's all. What is your submission? Huh? So then, what should we write? What have you done? Huh? Contrary to what you have stated in this thing. Huh? An additional government advocate has adopted the submissions. See, mister, he has abandoned you. So conveniently. Don't rely on the state government. This is what happens. Learn it with lighter weight. Learn it. Additional government advocate has adopted the submissions made by the learned counsel for the authority. Paragraph. So we have considered this. Huh? That has been dismissed. You told us. We have recorded it. That SLP has been dismissed, right? Yeah. All right. Yes, that's the question we have to decide. Fine. Thank you. We'll pass an order today itself, right? Yes. To write his submission of learned counsel for the authority submitted that no such averment has been made on behalf of the appellants that the surrounding lands have been denotified. Then support of submissions, right? Send it, Mr. Yes, this only this and yes. Where is it? Yes. Didn't get it. So interim order you would tell the date when it was passed, right? Agree.
Kumar,
Rights on body. He will not sell land to industry. They will not in sanction plans not from the KAD. EDFP says what you have a sanction from us. So that's the issue, but they got that. In fact, what has happened is, and I just undo your logic.
Yes, yes. Yes.
Facts are not. Not landlord 1982 and 1981. From 69 years of land. For setting up bulk chemical plants. Two agreements of lease of sale are made. And what the agreement of sale of lease of sale not subsequent to not by constructing the factory. They will not executed registered CD. In fact, one thing what I was bringing a lot of the lease of sale will not specifically mandate para 46 and page 46 and 55 specifically mandate that I must obtain not sanction plan for KIAD sales area development. CD also specifies that not any additional construction I have to get approval from the industrial area development board. Page 62 next page we are
Page.
The first is can I persuade you to get page 1? Page 1 will serial number 2 sub para 2. Not serial the second schedule agreement. Specified the plans, elevation, the activity shall be approved by the approved authorized officer AIT. Then our CAD also has a similar clause. Page 2 at the top. After I completed the building, CAD also specified blueprints for additional construction existing buildings and be really not approved. In writing by the but when I wanted to set up the tablet factory, I went to the BBMP also. When I went to the BBMP will not sought for certain document. Thereafter, I just no, we done, you go to the KAD. So that I applied to KAD, got the sanction, completed the building, 22, 12 years are over. Ever since not I completed. Plan was approved for page 9 and page 3. After I went to the BBMP, they said you have to go to the KID. KID will not the income CAD do not specify. So that I went there. They approved of it. I completed the construction. Spent about 68 crores to page serial number 10. Certificate issued by the engineer that I have spent that much, but is also there. 2011, after the entire thing was completed, BBF assistant executive engineer issues a notice, which I am not saying that you should have got plans from us. That was challenged and this one court not granted this stay. In 2011, I completed the fact. This also got the learned signature dismissed the expedition, saying that I must not only obtain sanction plan from the KAD but also from BBM. In fact, government has issued, I have filed a memo. Government has issued a circular, which my lords government stating that it's the KAD alone which has to from whom I have to obtain the sanction. This is a short question from my lords.
So 2nd February 2016
Yes,
clarifies this.
yes, but that I have placed for my lord.
Hmm.
The memo was not dated 26/10/2018.
Six 10/2019. 18. 18 and 19.
Memo dated 18.
18.
It's chronological sequence. Yep. Yeah. You say that that government order finds the BBMP.
Specifically, we so far that BDA is concerned about building plans have to be approved from the BDA. As far as about EMIT, EMRPL, money is not towards from it. But as far as others who are concerned, not housing board and industry area.
Yes, Mr. A government order. Huh?
They must obtain the rights. Their own.
Seven nine 18.
Level 9.
7-9.
Huh?
That 11.9 memo, there is no government notification. No.
11-9. Ah, yes. 2/2/2016, right? This. Yes. Is the meeting 28, 128 page. 28.
11.9, there are two memos. Yes.
Page not 2 is the another. Page 5 not is the English version. And running page not 7, my first. R5. Comment meticulously verify the matter again and pass all in order by modifying comment order. By dropping KDK and TSIDC industry areas from got the mandate to obtain DBNP. Nice.
As per the order dated 2/2/2016. Then last open January.
So have you gone through his synopsis?
Yes.
What they say is that this area is included in the limits of municipal corporation, and in the year 2007, therefore provisions of the Act apply, BBMP Act apply to any construction. Then section 300 requires, he has referred to section 300 and building bylaw 2.49. Building bylaws.
Now the question is not general act.
Hmm.
It should be. What God say, you have to obtain what KDP regulations specify that what you have to obtain what regulations. Yes, sir. Assam. Regulations. Just read it, what regulations. Yes.
KTB, sir, if there is a plan, whatever KTB plan, if there is a violation.
These regulation. IADB regulation they provide for.
If there is a violation, if there is for the term.
Obviously, IADB. Regulation.
Not the regulation or the building regulations are there. That a lot may come to picture one.
Building 1969.
Yes, sir.
What is
Picture one about building regulations.
166.
Right.
Yes.
6 feet.
Yes.
A lot more than half the party. No construction, no construction work shall be commenced unless land elevations. Questions already. And. That at any time will be, except similar things.
That's right. This will prevail.
Same and it's class B.
Shall be constructed in accordance with municipal bylaws.
Yes.
By officers authorized by the board.
Outside in the regulations, it is not. Building plans are not in accordance with the municipal bylaw. In section 47 here, what the act. This is a special act, but there's no idea. 47. Here.
Yes, Mr. Anything else? Yes.
After elected, and any next class get to not take Motion complaints like any section are the adopted during the continuation of the demand of within the all bylaw rule and regulation of the municipality. It is their agreement. They have admitted those classes. And even a class A will not. To observe and to argue regulations and bylaws of the local authority. They have to follow all rules of local authority bylaw. They have admitted and law 3, page 46. All buildings shall be constructed in accordance with the building bylaw. They are not denied this class while executing they are more it said petition around gate with certain conditions. H61 and R but rule and page 61. It was said that fellow object we are the poor of
Reasoning one.
utilize the balance and the that was the local authority. And she two are but on second page 62. The particular shall observe and conform with the bylaw, rules and regulations of municipal authority. There is the condition in the sale and they have to follow it. When the sale action are paid in it is their letter. They are admitted and they requested to issue license. And this our new since they requested to grant license. They have not and they have the consent. Therefore, we have issued notice and it's in
You see that? The other is learned since the kids in the they have to often flex in local. Thank you. Yes, no, no, it's all right. All right. Fine. Yes. Recovers. Yes. Mr. This intra-court appeal emanates from an order dated 10th of July 2014 passed by learned single judge by which the writ petition preferred by the appellant has been dismissed. And is stated 20th-10-2011 issued by Priyat Banguru Mahanagar Palike herein after referred to as BBMP, requiring the petitioner to obtain a building license under the provisions of what Act? BBMP Act, right? Under the provisions of Karnataka Municipal Corporation Act has been upheld. Paragraph. Facts leading to filing of this appeal briefly stated are that appellant is a pharmaceutical company which is engaged in the business of manufacturing and marketing pharmaceutical products. Full stop. The Karnataka Industrial Area Development Board, even after referred to as KIADB, plotted industrial plot in survey number 5/1D, 5/2E, 6/2F and 6/2A, and other survey numbers in Venkatala village, Yelahanka Hubli, Bangalore North Taluk, measuring 69 acres and 30 guntas. Stop. 30 guntas for setting up of a bulk chemical plant. Full stop. Thereafter, 2 lease cum sale deeds were executed on 25/5/1980 and 30th/6/1981 by the board by KIADB in favor of the appellant. Full stop. Clause 3 of second schedule to the aforesaid document specifies, provides that plans, elevations, and sanctions for the factory building shall be approved by the authorized officer of KIADB. Paragraph. Appellant, on the basis of the lease cum sale deeds executed in its favor, set up bulk chemical plants on the land allotted to it, and thereafter, in terms of the agreement for lease cum sale, the KIADB on 19/12/2003 sold the sold the plot, sold the land to the appellant. Stop. The SAT also contains a stipulation that blueprints for additional construction of existing building shall be duly got approved in writing from the Chief Development Officer of the KIADB. Full stop. Appellant. With an intention to set up a tablet manufacturing plant on the land allotted to it, submitted the drawings for approval to Commissioner BBMP. The Commissioner of BBMP on 6/4/2010 sought certain documents which were submitted by the appellant on 28/4/2010. The basis of the advice tendered by the officials of the BBMP, the appellant approached KIADB for approval of the factory building plan. The appellant was advised to deposit an amount of ₹10,72,281. Full stop. The appellant thereupon deposited the aforesaid amount and was granted approval for factory building plan on 30/9/2010. What submitted? What have you written this 30/9/2010?
The appellant thereupon deposited the aforesaid amount and was granted the approval for a factory building plan on
13/10/2010. 13/10/2010. Paragraph. The appellant, in furtherance of the permission granted to it by KIADB, constructed the plan in accordance with the plan sanctioned by KIADB by spending an amount of ₹68 crores. Full stop. A certificate of full stop. Thereafter, after the building was almost completed, the Assistant Executive Engineer of BBMP issued a notice dated 2010/2011, by which appellant was asked to obtain license from BBMP after paying necessary fee, and the appellant was further directed to stop any further construction activity. Full stop. The appellant challenged the aforesaid notice in a writ petition. Full stop. The learned single judge, by an order dated 10th July 2014, inter alia held that the appellant is required to obtain license from the BBMP. Full stop. It was further held that there is no conflict between the provisions of the Karnataka Municipal Corporation Act and the KIAD Act. Right, the whole thing. KIAD Act. Accordingly, the petition preferred by the appellant was dismissed. In the aforesaid factual background, this appeal has been filed. Learned Senior Counsel for the appellant. Learned Senior Counsel for the appellant, while inviting the attention of this court to the regulations, namely Karnataka Industrial Areas Development Board Regulations 1969. While inviting the attention of this court to Regulation 16, to Annexure 1, of the whole right thing, the Karnataka Industrial Areas Development Board Regulations 1969, submitted that the aforesaid regulation requires the appellant to obtain the approval of the officer authorized by the board. It is further submitted that the construction of the factory building, what factory? Factory building.
Tablet.
Huh?
Tablet factory building.
Has been raised after obtaining permission of the competent officer of the board. Full stop. It is also submitted that Karnataka Industrial Areas Development Act 1966 is a special act which prevails over the provisions of the Karnataka Municipal Corporation Act, which is a general law. It is also submitted that the provisions of KIAD Act 1966 have an overriding effect over any other provision of law. In this connection, a reference has been made to Section 47 of the Act. Paragraph. On the other hand, learned counsel for respondent. On the other hand, learned counsel for the respondent submitted that the appellant was allotted an area of 69 acres and 39 guntas by KIADB. It is also pointed out that the aforesaid area was included in the jurisdiction of BBMP in the month of January 2007, and therefore the provisions of the Karnataka Municipal Corporation Act are applicable. It is urged that that under Section 299 of the Karnataka Municipal Corporation Act, the appellant was under an obligation to apply for a plan and for the plan, and new construction of the building could have been raised without obtaining the permission of the BBMP. Yeah. Whatever you have submitted, right? So you have argued, Mr. Now, Delhi, start preparing SLP. This is what you have written. You have written in paragraph 3. We are not sitting here to explain it to you, Mr. Sorry. Yes.
It urged that under Section 299 of the KMC Act, the appellant was under an obligation to apply for the plan.
And
No construction.
and no construction work would have been commenced without obtaining the approval from the commissioner. Our attention has also been invited to clause 2.49 of the BBMP building bylaws 2003. And it has been contended that without obtaining permission of the authority, the work would not have commenced. Full stop. It is further. It is also pointed out that petitioner has that the appellant has violated the conditions contained in the registered sale deed dated 19/12/2013, which provides that that it has to obtain prior not a petitioner, appellant, which provides that it shall obtain prior approval of the board for utilizing the land in addition to which provides that the appellant shall conform to the requirements of bylaws, rules and regulations of municipality or any other body having authority. Full stop. It is further submitted that the appellant itself had submitted a communication dated 28/10/2011 to the respondent, in which an undertaking was in which it was stated that the appellant is ready and willing to pay the license fee. Paragraph. License fee. Full stop. Attention of this court has also been invited to to clause 3 of regulation of the so regulations 1999, right? You say here in after referred to as 99 regulations. 99 regulations. paragraph. We have considered the submissions on both sides in the Peru's period. Admittedly, the appellant has been allotted 60, appellant has been allotted land in question by the KIADB for the purposes of setting up of an industry. What for setting up of? Huh? For setting up of bulk chemicals plant, right? For setting up of bulk chemical plants, full stop. In exercise of powers under section 41 within bracket 2 within bracket small b of the Karnataka industrial areas, you say here in after it was 1966 Act, right? The beginning somewhere 1966 Act, comma the state government has no, and after obtaining prior approval of the state government, comma the Karnataka industrial areas development board has made the regulations, namely so and so. We have said somewhere, right? Namely so and so regulations. Full stop. Regulation 16 deals with building regulations. Full stop. The relevant text act of regulation 16 reads as under. Relevant text act reads as under. Paragraph. Thus, from perusal of the aforesaid regulation, it is evident that the holder of a plot has to construct a building in accordance with the municipal bylaws and regulations, and in accordance with the plans and elevations approved by the officer authorized by the board. Full stop. Thus, full stop. The regulation 16 unequivocally provides that the permission that the plans and elevations have to be approved by the officer authorized by the board, and the construction which has to be raised by plot holder has to be in accordance with the municipal bylaws and regulations. Full stop. The provisions of full stop section 47 of the full stop provisions of section 6 provisions of 1966 Act. The 1966 Act is a special act which deals with establishment and development of industries in suitable areas of the state government. Full stop. It is a specific. It is a special law relating to development of industries in the state of Karnataka, and prevails over the general law, namely the Karnataka Municipal Corporation Act, so and so. Full stop. Paragraph. The full stop. Therefore, full stop. The agreement. Full stop. The agreement executed in favor of the appellant also contains stipulation that the plans, elevations, and sanctions for the factory building shall be approved by the authorized officer of KIADB. Full stop. The appellant, in accordance with the regulation, regulation 16 of the regulation, has obtained the approval from the competent authority after has raised the construction of the factory building. There is no requirement in law. Full stop. The requirement contained in the provisions of Karnataka Municipal Corporation Act do not apply to the case of the appellant as the case of the appellant is governed by the provisions of so and so act. Case of the appellant insofar as it case of the appellant is governed by the act. Full stop. The paragraph. The finding paragraph. The finding paragraph. However, the finding full stop. The regulation 16 of the regulations has been misinterpreted by learned single judge, and it has been held that that for raising industrial constructions, the appellant is what have you written?
The regulation 16 of the regulations has been misinterpreted by the learned single judge.
And it has been held that the appellant is required to obtain the permission of the so and so. Full stop. For the aforementioned, the as is stated supra, the under the provisions of KIAD Act, the appellant is required to obtain the approval from the competent authority or obtain the approval from this thing, see regulation from the officer authorized by the board. The appellant has admittedly obtained the approval from the authorized officer of the board. The appellant is not required to obtain any permission from so and so from the corporation for raising what for raising
Factory building.
chemical plant. Full stop. The cause notice is there. Notice requiring the petitioner to obtain the license from PPMP is per se without jurisdiction and cannot be sustained in the IU. It is accordingly cannot be sustained in the IU paragraph. For the aforementioned reasons, order dated passed by learned single judge is hereby set aside. The impugned notice so is hereby quashed. In the result, appeal is allowed.
Forty-five. The next one ready, SS 40.
What happened to 44? This was 44.
Yes.
Yes, ma'am. Did you make a claim before the family court? Not evidence, no evidence adduced, nothing. set aside to this extent and grant a liberty to file. So we will set aside this order and you file a petition, read evidence. That's why you should read evidence, right? File a petition under section 25, lead evidence, and this thing. The claim, whatever, 30 lakhs, 50 lakhs, 5 crore, 50 crore. What evidence have you led, man? Prove that it should be 30 lakhs or 50 lakhs. What is it? We don't know what's the share. Have you stated?
What is the document produced with regard to the ancestral property? What is the document?
Please appreciate, madam. There's no distinct material on record to enhance the figure from 5 lakhs to 30 lakhs. Then why not 1 crore? Why not 5 crore? Anything ancestral property. What is the value of his share? Nothing. Understand, right?
You set aside this judgment and give liberty to you. You file a fresh
File a
petition.
petition. Lead evidence. Mr.
It's perspective under section 19 of the Court Act as prescribed. Assailing the statement and the plea dated so and so passing MC number so and so by the family court, Dakshin Kannada Mangalore, insofar as it relates to being not satisfied with the amount of permanent money awarded to the appellant. Right, while following the marriage of appellant with the respondent. The appellant had also there is no development. The fact of the case has been from the record that may be necessary for the purpose of disposal of his appeal act. Marriage of appellant with the respondent was solemnized on 30/11/2003 at the court will keep the temple Sandanam of Mudalitra as per the rights and customs prevailing in one community, and it was an arranged marriage. Wedlock, the couple have a, you have one son. Couple have a son. The appellant is presently the study of the husband and wife. For a short period of time, but afterwards they develop misunderstanding and resulting their relationship got strained and ultimately had deserted the company of the respondent, stayed to the parents along with their son. That filed MC number 394 of 2015 before the family court. Under section 13(1)(1)(a), 1B, IA, and B of the seeking resolution of her marriage with the respondent. It said proceedings with respondent had entered a current, therefore he was placed as part. The judge of the family court Judgment and decree dated. He had. And though there was no application filed by the seeking permanent alimony, had awarded an amount of fees that as permanent alimony to the appellant and has directed to pay this amount within a period of 3 months from the date of the judgment. Awarded by the Adjournment Court. Appellant wife is before this court. And counsel compared to the assets of the she submits that the respondent has sharing the family property. He has not disputed the same before the. You said he has not disputed the same. He has placed ex parte before the trial court. Where is the question of saying he has not disputed? Yes, yes.
She submits that the respondent has got share in the family property and he has not disputed the same.
Appellant is taking care of the minor child who is presently studying, and therefore the amount of rupees 5 lakh awarded as permanent alimony needs to be announced. Needs to be announced. We have gone through the, we have carefully considered the submissions made on behalf of the client and also on the material level. Substantiated case, the appellant had examined herself court and had got 5 documents which are invitation, photo, certificate and family. Except the said documents, no other documents are on behalf of the appellant before the family. It is also not in dispute that the appellant had not made an application before the permanent alimony, nor had she placed any material before the family court on it or to prove the assets and liabilities of the respondent. Stating that the respondent has got a share in his family property. Yeah. Either before or before the court, the income of the respondent or the liabilities of the appellant submits it is the case of the appellant that the amount of money awarded to her by the court is very meager. And in circumstances, we are of the considered view that is the cost by the aside to the extent leads to directing respondent to pay permanent alimony of rupees 5 lakh to the appellant. Set aside the liberty to the appellant to file a separate petition under section 25 of the Marriage Act before the files of court. Seeking permanent alimony with the ends of justice. The miscellaneous first appeal is allowed. The informed judgment and decree get so and so insofar as it relates to directing the respondent to pay permanent alimony with finance to the appellant is set aside. And the appellant is at liberty to file a separate petition before the family court. Under section 25 of the Act, seeking permanent alimony from the respondent. And if such a petition is filed, the family court shall consider and dispose of the same in accordance with the
For 46, the NS Bhatt, government educate, education.
You are ready.
One minute.
The cross objection. Cross objection. You are saying that the appeal which was filed was withdrawn.
Feel by the husband as well. Get.
And the petitioner was a tenant right from the year 1930 and was the usually party kind and Johnson teacher. Usually has a very common person and usually and nothing facts I answer is the only person who has considered the petition. The landlord is the responsible number 2 to 9. Our main event is that we have paid a targeted rent visit to the landlord and we are intention to put the land. So what to tell you see, from 1930, I have submitted about 8 documents showing targeting the targeted and for particular year during the cultivating the talent on the way of that. So I have examined my neighborhood, one Mr. Mariam and land. This is of your NBC. The seven documents which have been relied upon by me, and on the basis of that, land was corrected and what is dependent. What is specifically stated that I am going certain features of I am cultivating this and there is also one the land on the basis of the material case document and the partner has done what made the right to my way. And you know by the same here before the petition is on the right. In that year, the what from the next agreement. Page 26. Examine the land on 4/2075. Recording of the gun statement in contrary to mandatory requirement of CM fiscal law. That is why head by the value law. In the right of petition, on this part, the material plan 1, 2, 3, so far as 8 to 7 number 38, part A of voting area. So far as another number 23, 7, 5. The last here. Let us say that we remind matter on that. Thereafter, you know, the same case, people recharging also issue. Like approach the apex code side, right? You petition has to, instead of reminding the matter, the petition has to be decided on very system. Now the last is or to a petition. Next agreement, I think in pay. Three matter. Now here, this, my reputation is confirm with the audit. I two crucial points for your audit. Now the inquiry has to be conducted only in respect of 23/3A, not 23/1C7. So far as 23C7 has become final, because landlord, I have no claim to audit. So it is admitted back by the landlord. So at that 23C7, when it is become final. And so far as other than the two, no, the lines on the of some record of rights to the year 1974 and 1597 after all of the records from the government. The earliest point I was on the calculation. That's an important point. And the alternate is also conducted. No, he lied to you without considering the early evidence. And what my specific submission before you not be that. The landlord has to give a specific finding regarding is the tenant or is not a tenant. Under the effect of the peculiar statement, have probably calculated in that another. Here, the landlord has produced the rent stating that I will be giving rent to the building. So both documents have been appreciated. No, the landlord simply rejected my question. Consider this of it, this rent. The point you want to say. After the remand, on 1914 to 1989, I have not given an opportunity to cross-examine the witness. As per rule 17, fine, a cross-examination in order to appreciate the documents content. So after remand, there is no opportunity to me to cross-examine the witness. It's clear that mine is not 17. That's the way.
When was he examined? When? When, Mister? There has to be dates. When you say that you are not granted opportunity for cross-examination, you have to give the dates. Simply saying that I was not given cross-examination.
So it includes the power to remand the land of the final authority over its energy estimate. Under argument,
Question is very simple. You said you are not given opportunity to cross-examine. When was he examined? You don't produce anything as to when the examination, as to when was the denial of your cross-examination. Nothing is there. Simply make a statement that I was not given an opportunity of cross. Show it. Show it. Yes, sir. Nothing, that's it. It's
28/3/2002.
where do you get it?
92.
Actually, it's the it's an order of the tribunal.
So, no opportunity to cross examine. As per rule 17, board that would be remarked, that there is no problem.
From this order of the tribunal, where do you get that there was no opportunity for cross-examination?
ಅದು ಬಂದಿದ್ದಾರೆ ನಾನು ಕೊಡಿ ಬರುವಾಗ ಚೆಕ್ ಮಾಡಿದೆ and sufficient time has been given. The applicant and appellant have to complete their arguments and no documentation to that. The inquiry has been closed.
Where have they said that you had requested for cross-examination and it is rejected? Where have they said? Why do you say it is not granted? Why do you say it was not granted? You have to show it from the order sheet, not from the order of the tribunal.
The land has not. What you can see 28 second number 28 and specifically reminded only.
Yes, you can continue if that is your submission. Yes. Yes, you are not ready to answer the court question. Yes, then show from where is the order sheet which shows that you were not. Show it to us, Mister. Who has to look into it? Yes, you have not verified the. You have not looked into the records then. Have you looked into the records?
As per rule 17, you are to video and estimating order has to be passed. My only clearance before you order to be two sets of documents. One of the document came back at the time. And after different my they are not different documents. That is called of date 19/8/1989. After voting an inquiry on 1958 that 48% and 48% was opened. Both parties. The survey of the district on the that the district to be affected by the land. It mentioned in the instruction note and it is that the applicant are cultivating potato, black gram, veg, and planted coconut, banana, etc. Also grown collecting creating fish in the land. As for 1 the land is planted having line of for example in possibility to was and so far as three there are two movements, one is for permanent movement, and that's for permanent and thereafter and have has line of one and 200 as per one pattern is clear bar. Independent. From temporary or banking into our and no benefit to us. Because I independently.
Very good. List for further hearing tomorrow. Yes. Tomorrow. 50. Rest for adjournment list next week. Which case 50? He is seeking an adjournment, right? We'll deal with it on the next day. Next day, we will deal with. We will deal with it on the next day. Don't worry. You have filed, right? You have realized the mistake. That was the only purpose of telling. Next, Mr. You did not hear what did he say? There is a marriage in his family. He is not available. That's why we are adjourning it. No order is being passed against him. On his request, adjourn to next week.